Yeah, there we go.
Carol, I'm so sorry. I'm out of practice.
You're good. No problem.
Okay. So
Well,
at this point, Mr. Vogel, will you please help with the roll call?
Certainly, Mr. Chair, and thank you for calling us to order. Ms. Dawson?
Present.
Mr. Geffen?
Present.
All right, Mr. Urban?
Present.
Ms. Kaser? Ms. Kaser. Judge Kulik?
Present.
Mr. Page?
Present.
Representative Robbins?
Present.
Thank you. Mr. Sandoval? Mr. Sandoval? Ms. Sherlock? Ms. Sherlock? Mr. Tatum? Mr. Tatum. Mr. Chair, 6 of the 10 members are present. A quorum is present.
Thank you much, Mr. Vogel. It's been, I've been informed that the most recent disqualification subcommittee meeting from April 5th of 2022 was posted on the task force website, and those minutes are posted, and then just opening it up now to see if anybody has any calls for corrections, modifications, or any additions, submissions at all. All right, seeing no hands raised or anybody indicating there are any needs for a change, we're going to, at this point, we're going to accept and adopt those meeting minutes. Great. And so today we have a wonderful list of information, I think, from the last meeting that Ms. Evans, Vice Chair Evans, presided over, to kind of set forth what we're going to be talking about kind of each meeting moving forward. And we're tasked today kind of with continuing what we've already had, I think, a pretty deep and thoughtful discussion of juvenile records, and specifically how those juvenile records should be used when making determinations of disqualification. Or I think we can have an open discussion as much as we want, but one of the things we want to do is sort of move towards some of these actionable items, specifically coming up with proposals for how juvenile records should be used. I recall Judge Kulik making some thoughtful recommendations or some ideas in previous meetings. So I think that's really one of the goals today, is come up with some ideas. We can see how many we get and maybe open up for discussion. It's certainly more of a brainstorming idea, I think, today, coming up with ideas that might work, because I think there are a lot of different ways to go about this. Before we do that, do you think, Vice Chair Evans, that is consistent with the sort of course that you've set through the last meeting?
Well, that was what we talked about, and I think it just would kind of help the data subcommittee kind of navigate the work there if we did that in this subcommittee as well as the other subcommittee. But I think that would be up to you.
Can you explain that a little bit more? That it would be, explain what would be consistent or inconsistent. I apologize.
So I think, like, if let me just look really quick at so if you all were working on like juvenile records for the next 3 weeks, and the any data or any work that you all needed to come out of the data sets that we have was around juvenile stuff, that we as the data subcommittee could be pulling those type of data. And then as well as the remedy subcommittee is going to be working on permanent stuff. So that way data has kind of 2 sets of things that we're looking for and working on at one time. And then those 2 subcommittees kind of move on, and then data can also move on and be working on specific work at that time.
Okay,
so
I think I'm tracking now, and I appreciate it. So let's open it up. I mean, I think the goal today would be able to come up with a list of some ideas that we can bring forward, even as early as this Friday, to share with the larger group. Or here are some ideas, not voting on things. Some might seem too aggressive, some might seem too mild, but let's put pen to paper and see what we can come up with today. And I'm going to start it out. What if we had a scenario where once an individual, a juvenile, was no longer under juvenile supervision, that we didn't use their record for disqualifications. So I'd like that added to the list. Obviously, there will be some pushback on that one, but that's how I'm starting it. Yeah, Judge Kulik, please.
I think a real easy one is to not use any juvenile records for an offense committed under age 14. And the reason is that if you can't try them as an adult, it's not serious enough for that. And anyone under 14 is so young. I'm thinking even of the serious offenses like the sex offenses. If they don't reoffend into their adulthood, clearly that's something isolated to their childhood when their brain development is not far enough along to charge them with complete responsibility, of somebody who has impulse control. So I would disregard everything under age 14. If somebody continues into their teenage years and young adulthood, obviously, to commit other serious crimes, they'll be disqualified for that, but nothing under age 14.
And I just want to get a little more. When would, if you applied that standard, Judge, would it be when the supervision ended, or just at any time? Like if the person were 13 and 300 days, if there's any supervision from the court, would there be a disqualification until they're off?
Well, because by the time they reach adulthood and they are applying for licensure, unless there are licenses that juveniles can have, I'm thinking they're going to hit that age. And if they have an offense when they're 10, 11, 12, they will, because they can't be tried as an adult and they can't be on extended juvenile jurisdiction. Then by the time it'll all happen at the same time is what I'm trying to say. They'll hit 18 and they will be off, or 19. So in a way, what you're suggesting kind of overlaps nicely with it.
Okay. So no juvenile records under age of 14. Thank you so much, Judge. All right. Anybody else have a thought? Yeah, Ms. Dawson, please.
So I think mine's going to be probably a little bit even further than everybody else. More just based on, I think, some of the research that we've done in the remedies subcommittee, that the language we're finding in both the Adam Walsh Act as well as other states really only use the word convicted. We really are not finding adjudication or preponderance of the evidence, which is something the remedies subcommittee is looking at, which is why we started to do that dive. And so I guess looking at all of that, I see an argument for really only using records where there's an EJJ certification or a conviction.
I'm just writing down. So can I ask, in that situation, if there's EJJ, then how would, I guess we're just talking juvenile records. So if it's EJJ or an adult conviction, then that's something else, but we just wouldn't use juvenile records in the disqualification.
That's correct. And I think EJJ, I look at it as, I think Judge Kulik made a very good point at one of our other meetings about when you look at the EJJ and the certification, there's been that additional study, that additional oversight, things like that, I think is important. And I think gives kind of that extra security, especially knowing what we know about brain development, and even just looking back on myself as a teenager, it's just not reflective. And I think they should be treated differently.
And I would want to remind Ms. Dawson that this is being recorded, so be careful with any admissions. No, I'm just kidding, Ms. Dawson. So can you, and I'll get to you, Mr. Page, in just a sec. I did have a question about EJJ. I've never done a ton of EJJ work. What are the types of cases that end up going through EJJ?
Well, the most recent one that I had was aiding and abetting second-degree murder. And in that case, the child was still 14, just about a month shy, or 2 at most, of being 15. And the prosecutor actually wanted to have the child certified as an adult, but between the probation office and especially the EJJ report, and I think I mentioned, it was such a deep dive into this child's background, and the examiner went further and looked at the health and legal records of the kid's mom, and that is how we got our diagnosis for the very first time that he was on the fetal alcohol spectrum, because mom gave birth at 17 and she had underage drinking adjudications before, during, and after his birth. So that gave us some insight, and it was very helpful and to understand how the kid's brain worked, what his strengths were, what his weaknesses were, because that was probably a 40-page report all about this kid and the testing and his school records and his medical records. It was an amazing body of information. And by the way, he's doing really well.
Thank you so much, Judge. Can you think of a time where anybody on this with EJJ that it was, I mean, it seems like the aiding and abetting murder, pretty darn serious. Any other EJJ cases that were of a kind of a lesser severity?
So typically these kinds of cases involve serious, mostly violent, including murder, attempted murder, aggravated robbery, weapons charges, carjacking, and sex crimes.
On occasion, something a little less, still serious, not as serious, but it's also the amount of time we have left. Because if you've got a kid who is 17 and 11 months, we will not have much time to do, give this kid some services and see if we can get him on the right track again. And so extended juvenile jurisdiction is for the super serious, and also to give us enough time to try and do a little rehabilitation before they are thoroughly into the adult system.
Okay, that makes it an enormous amount of sense. And we can talk about this a little bit more in a minute, but I want to get to Mr. Page. Mr. Page, please.
Thank you, Mr. Chair. So I think if our goal is to protect populations that might be vulnerable, that these individuals might be working with, I don't know that I necessarily agree with Ms. Dawson that using a conviction as the standard of proof in these cases just is appropriate, just because that standard is so high, and we know there are many times that crime or criminal activity occurs, and there are 11 jurors that agree that they did that, but one juror didn't disagree, or the evidence isn't there for some other reason, and that doesn't mean that the conduct that would cause concern for licensing didn't occur. This is not just to say no to Ms. Dawson, who is very thoughtful. My proposal would be to mirror the disqualification period, or mirror the foster care licensing statute that was passed last year for purposes of determining the disqualification timing, which is something we discussed a few meetings ago. That would be if there is a conviction and you are committed to the Department of Corrections, then the disqualification period would run from the time of starting after you are released. If you receive a probationary sentence, it would run from the time of your conviction date, and if it's from the preponderance of the evidence, it would come from the charge or the finding, an administrative finding, I guess. So that would be the time periods that the disqualification period would run. That's slightly different than what has been a slightly different category of idea that has been discussed so far. But that would be one of my proposals.
And Mr. Page, just so we're clear on this, those are the only changes to the juvenile one. And this is.
And I guess, Mr. Chair, I wasn't sure if we were just talking about juvenile cases at the moment. If that is the case, then, I do think the same principle could possibly apply. I haven't completely thought it up through just as to juveniles, but I apologize if I was premature in my comment.
No, not at all. And I think it's a little difficult to just cut the statute up and say we're only talking juveniles sometimes, because we might have changes that apply to kind of everybody. So we'll figure that out. I think I get it 100%. Thanks so much, Mr. Page. Ms. Dawson.
Thank you. Just one more thing, and this was partially from our remedies subcommittee, was I think kind of the request was made through our committee to discuss with this one, the feeling that even if juvenile records are going to be left in, that they're not permanent. So that it's not a permanent bar.
And would that be true with, I mean, it would just be everything, the max would be 15, or we just remove the permanent piece? How would that, what would that look like?
I think there's definitely some openness as to what that would look like, whether it's somebody who has a permanent juvenile disqualification would at least have an opportunity to show rehabilitation. I think something even along those lines, just at least an opportunity.
So one of the solutions would be that the permanent piece stays, but someone would, if a disqualification is based on a juvenile record, would have access to the set aside process. Is that?
Yes.
Okay. All right.
Yeah. And that's of course whatever the subcommittee ultimately comes to for its recommendation regarding juvenile records. If the ultimate recommendation is that they remain, and that whatever the offense could be permanent, that they at least be offered some opportunity.
Okay. I see that Ms. Sherlock has joined us, and I just wanted to kind of give, before we get to you, Vice Chair Evans, Ms. Sherlock, we're just trying to come up with, just sort of doing some brainstorming on possible changes to how juvenile delinquency cases are dealt with within the disqualification statute. So we're just sort of brainstorming on them.
And Mr. Chair, I apologize. I do need to leave early today. I'll be here for a few more minutes, but then I'll be taken off.
We appreciate any of your time, even if it's a truncated version. We appreciate you, Mr. Page. Ms. Evans.
Can I make a statement before that? It was a question that you asked, Chair Geffen. I was reviewing the changes that are going into effect on July 1st, 2022 again, on the background studies for child foster care licensing. And it looks like the changes only really impact child foster care licensing. And I noted that one of the changes is saying that for what would be considered a permanent DQ previously or something in that arena, that there are no, of course, there's no set aside, there's no variance for those, but it did indicate that if a youth committed that crime and is still a youth, so the background study is being submitted while the person is still a youth, there could be a variance granted. But the same is not true if a person committed that crime as a juvenile, but is now an adult, which I thought was very odd. Does anyone else know anything about this? And am I reading that correctly in the statute? Or it's actually in bill language currently. It hasn't been passed yet. Is anyone else familiar with that?
Mr. Page, you worked pretty closely on that. Do you have any recollection of that, or does anybody else? Okay. You know, Ms. Sherlock, what we could do is go to Joanna Woolman with that question. If you would hold my hand through that in an email, and just sort of cite to it, and we'll get it to Ms. Woolman and ask for her feedback, because that seems pretty inconsistent with the intent as I understood it.
Right. I mean, I just feel like if someone committed that and is now a 35-year-old person, it seems if we're going to give a variance, if the person happens to be a minor, that doesn't make sense to me. So I'll look for the language that I found, and I'll touch base with you, Chair Geffen.
Oh, thanks so much. And
Thank you.
Appreciate it. Ms. Evans.
So I would say this for Max, but also for the rest of us as well. Like, if a juvenile, be it 14, 15, 16, committed a crime like, second degree assault with a weapon or carjacking, there's so many of them going on now, with the understanding that their frontal lobes aren't fully developed, and then did not commit another crime for how long? 10 years. Now that 16-year-old is 26 and it went to college and wants to do work with people that are involved in their community. Like, do we want to let them? Like, do we want to? And that's the thing about this. So you guys keep, and I'm going to be 100% transparent with you. I don't know how to be anything but my authentic self. Like, I still don't really understand the difference between a permanent disqualification and a bar. I'm not going to lie. But do we have a different thing than we've had before, where for 10 years, somebody can't even apply for a set aside? Like, they have this 10-year, where they don't get a chance, but then after 10 years, if they're crime free, then they are able to then apply for a set aside to be able to show for the last 10 years, here are the things that they've done to show themselves. Because now you can, if you have a 10-year disqualification, you can apply after 2 years and ask for a set aside, right? But do we have this other thing where these kids at 16 or an adult that committed a crime has a amount of time with some of these crimes that aren't the federal crimes of violence, but they're crimes where we're nervous of somebody and they did a terrible thing, like a domestic violence. But they haven't done that for 10 years, and they've done all of these things that are, so to start with, though, I mean, that's permanent stuff, but to start with these juveniles, because here's another place we could talk about this, is there a time frame that somebody has not done anything like that again, that we want to offer them not a chance to work, but a chance to plead their case that they've changed? Because we are a system and a community that believes in redemption. Because if we don't, we might as well just hang it up, you guys. And so what does that look like?
Why did they, and I'm just pushing back on this with, why don't we have a period of time and then it's just the disqualification period ends? Juvenile cases, couldn't you come up with a situation where if it's a juvenile offense, then it's a 7-year disqualification, and after this, and either they reoffend and they were disqualified based on that reoffense, or it's over? And I mean, pleading the case is adding a level to it. I just don't know if it's, my thought
well, that's what we do now, John. That's what we do now.
I know, but
this is with the set aside.
But this is our wish list. This is what we think we could do to make it better. And I really like that idea, though, Gina. I like the idea of not having it like for juveniles, and we're just talking juveniles, have it tiered out 7, 10, 15 permanent. Because if they're screwing up, they're going to get dinged up on something else.
Yep. I just, I'm always thinking about, like, because I'm down there, right? I'm always thinking about, like, what are we going to be able to get done? You can talk about wish lists, but I'm always thinking about the work at the end.
And we're going to we're going to do that. But, I don't think we should remove a discussion about some of the things that we think are right yet. I think we could make a list and say, here are some things, and then come up at the end and say, that's not going to fly, and here's why. Okay.
Because I personally don't think that there's anything that after a certain amount of time that a child should be able to come back from.
Explain that again.
Well, I just don't think that there shouldn't be, it should be a list this long, if there's going to be a list at all, that a child after redeeming themselves shouldn't be able to work. Like, they shouldn't be able to, because they're kids, like, and a kid at 16 and a kid at 35 looks very different. So
agreed. And I echo what Ms. Dawson said, who I was at 16. Maybe I wouldn't be so proud of that kid every day, but we mature.
but getting that done is going to look very different, John. And so, especially in this environment. And so I think, yep.
Got it. 100% agree.
Will, do we know what the feds say about adolescents? We looked into that at all?
Ms. Evans, that not off the top of my head. I think that's something that the remedies, Ms. Dawson's work in the remedies subcommittee is sort of working on. Not to put you on the spot, Ms. Dawson.
I don't know if you want me to elaborate.
Please.
Do they differentiate at all between adults and adolescents in that
Well, at
research we're
least
doing?
what we've seen is at least Adam Walsh, and I have it as a note to do some deeper digging on it, but specifically only uses the word convicted. I do believe because we had done some state surveys, I believe Iowa only uses the word convicted. Wisconsin may as well. So I know because we started looking at it to see what language was used by other states for purposes of looking at the preponderance of the evidence standard. And so that's just how it happened to stick out to us, but we didn't, because the juvenile records were going to be discussed here. I think that's something we could probably put together, but that wasn't the focus, but we did notice it.
And Ms. Evans, before I hijacked your proposal, will you walk me through it again so we can get it written in a way? It was certainly not my intent to do that, but I want to make sure we get it written as you described it.
Well, it's fine. Like, I mean, if we're just doing high level stuff and we don't want to talk about like getting it across the finish line, then, my recommendation would just be that the same thing as Lucas's then, that we don't have things that are permanent disqualifications for juveniles.
Do you think we should retain, so removing the permanency piece, do you think that we should have disqualifications for juveniles that are in the 7, 10, and 15 year?
I think we need to get rid of those 3 timeframes. And
Okay.
That's getting into adult stuff, but I think we should get rid of the timeframes. And then if we're going to have crimes of violence, have a time frame, and then property crimes. So what we've been talking about in remedies is like 5 years for felonies, and then something different. So I don't know that we're there yet.
Okay.
But maybe 5 years, a 5-year waiting period for after supervision, something like that.
And that would be the disqualification period, would be the 5 years after supervision expires?
Yes.
For property.
And
then violence was?
I think, John, I don't think we've gotten that far into the details. And some of that is because in the remedies subcommittee, we're really preparing a comparison because the Adam Walsh seems to use a permanent and then a 5-year. And the Adam Walsh really only looks at felonies. It actually, our interpretation of it is that it doesn't even include gross misdemeanors or misdemeanors. And so the really violent, your sex assaults, your homicides, I feel like I should be able to rattle this off by now, but they're all a permanent. And then actually your assaults, your regular assaults, so even your first, second degree assaults are a 5-year.
Got it.
And and I believe that Adam Walsh even uses the language from the date of it was committed.
Okay.
So that's just some of what, because the remedies subcommittee is looking at the actual list of permanent disqualifiers. And so that's where we started. That's what we're looking at. So that's what we're actually working on right now.
Okay. Does anybody else? Ms. Sherlock, please.
Thank you, Chair Geffen. Ms. Dawson, you were talking about the crimes that are in 4E, and that's the state statute mirrors that for both North Star kinship assistance and North Star adoption assistance. And the background study what is the bar or permanent is a felony conviction at any time for child abuse or neglect, spousal abuse, crime against a child, including child pornography, or a crime involving violence, including rape, sexual assault, or homicide, but not including other physical assault or battery, or a felony conviction within the past 5 years for physical assault, battery, or a drug-related offense. So I also saw some changes in the 2022 changes that are happening that tried to get at some of this. There's some permanent, there's some 5-year, but they're back to, it doesn't have to, in some ways they put in that it has to be a conviction, a felony conviction. In other places, it has to be that a crime occurred. So how do you determine a crime occurred? So yet not a conviction, because they specifically did not use the word conviction. So I think we're still at preponderance of evidence, I assume, right? That's what the crime occurred means. So the 4E language is much clearer and much simpler than anything we have in state law about these background studies. So I think they tried to sort of get at this, but they didn't get there. So just want to throw that out. Thank you.
Thank you. Yes, please, Judge.
Just a little bit of explanation for people who may not know a lot about the system. Even on some felony level drug matters, there can be a stay of adjudication, so conviction never enters, or a stay of imposition, which means if you're successful on probation, it drops down to a misdemeanor. So there's still a guilty plea to the felony level offense. So that would be the cases in which, yeah, you know, an offense occurred and there was a plea to it. And so the way we sentence certainly doesn't match the way we disqualify people.
Right. Thank you so much, Judge. And I think one of the things we want to be mindful of is those distinctions with stays of adjudications, diversions, stay of imps, because truthfully, our expungement law, which is pretty helpful, probably didn't do a great job of parsing through all those different types of stays and led to some probably unintended outcomes. Let's start with some of the ones. Well, does anybody else have an idea or a recommendation? Can be minor, could be major, that we want to kind of add to this list? Or should we talk about a few of them? And I think the next step would be to try to look at some of these critically. Let's do that. So mine was first, and I said pretty much we shouldn't use juvenile records after for disqualification purposes after the end of the the end of supervision. Who's got? I mean, let's talk negatives about that. Why is that a bad idea? And if we're thinking about safety, specifically safety of vulnerable individuals, why does that fail? Yes, Judge.
Well, if I'm going to play devil's advocate, a concern that I would have is there are juveniles that may commit seriously assaultive behavior, not be tried as an adult, but because maybe they're 15, 16, we decide that the jurisdiction till age 19 is enough to try and give them services that are rehabilitative, but they still hit adulthood and their brains still aren't fully developed and their impulse control still isn't all there when they are 19, 20, 21, 22, and they might otherwise be applying for licensure.
Makes sense. Okay. Who else wants to slam my idea? I love it. Ms. Sherlock, please.
I'm not sure I want to slam your proposal, but
oh, it's fun.
I do have like an argument on this. I mean, part of this for me is the disqualifications absolutely keep people from working or fostering, whatever the case may be. But if it's not an absolute DQ, that doesn't mean someone has to hire someone or has to give them a foster care license. You know what I mean? Like these should be maybe really extreme. and other things maybe can be more of a judgment. Like if it's one DQ, one conviction, and it was a long time ago, they can decide they believe that the risk is mitigated sufficiently. Or if it was like, as Judge Kulik is saying, it happened 2 years ago, their brain's still not fully developed. Somebody doesn't want to take a chance on that. And I know that gives more room for maybe gray areas and people making biased decisions, but people can make biased decisions in hiring all the time without a DQ. Like somebody doesn't have to hire someone. So I think we should err on the side of reducing the amount of things that absolutely keep people out.
I mean, it's always a good reminder, and thank you, Ms. Sherlock, that what we're really talking about is taking away an employer's ability to hire. I think Dave Irvin had talked earlier in one of our previous sessions just about knowing somebody after several years, seeing that person thrive and mature, and then trying to hire them and having that ability actually taken away by the department that they just didn't. I mean, because it's not, hey, it's not like Target where you get a background saying, here's a bunch of information on them, you make the decision. It's different. It's you can't. It's a misdemeanor to hire them. So I think that's a really good point. Although it gets even murkier, though, I think, Mr. Sherlock, because some juvenile records are not available to an employer. And when the department does a background study, it doesn't come back no, and here's everything on there. It just comes back no. So it does. I hate to even say that because I'm beating up my own my own idea, but it's a reality. Yeah, Ms. Dawson, please.
Well, and I don't know, and maybe this is more brainstorming and less really going after your point. So I apologize. But one thing, just as you brought that up, and I don't, if there's a way to sort of carve out, because Judge Kulik's idea of nothing under 14, having represented the 11, 12-year-old children, 13-year-olds, I mean, honestly, they're terrified. I think the court process is so above their head. I look at those clients so much differently than my other clients. And then kind of, so anywhere that 14, but anything under 16, which is still technically confidential, I don't know if there's a way to sort of parse that out. Of 14 to under 16 is treated even maybe something a little bit different, some oversight that's allowed, and 16 to 18, I don't know. I'm just kind of throwing it out there that, again, to that confidentiality, because there's also a part of me when I talk to these clients about when you're a child and still being able to have that confidentiality about who they are and what's going on, because especially if you want them to get help and to address the situation, to then know that can come back and maybe not all the information, but it still is used against them, I think is unfortunate. So I don't know exactly what that looks like, but that's just an idea.
Okay. And maybe that's a good segue into now we can attack Judge Kulik's idea.
Except I think I supported it, so yeah. I'm going to just be quiet.
Oh, you're being a chicken. All right. So I do have a comment about Judge Kulik's recommendation, and the one issue only is that, and I think Judge Kulik's right about seeking a license. You might be, 18, but you could have a background study during your juvenile years if, for example, you lived in a home and they were going to have family childcare. So oftentimes kids, let's say you got a 14-year-old kid, mom or dad starts the family childcare, they'll do a background study on that 14-year-old. And if one of these things comes up and triggers it, then they can't have their license. And I would defer to Ms. Sherlock on this. Is the same true if you have a child in a foster home?
You're talking about if there's a child in the home that has something on their background study. And the answer is it depends. Okay. There's some exceptions if that child is in the home because they were previously a foster child who has been adopted, for example, they made some exceptions to that because when foster parents adopted some kids, they had background checks that then made it impossible for them to continue fostering other kids. And so they made some exceptions for that. But generally speaking, if a juvenile is in a home, an adoptive home, we have to do background studies for adoption and foster care. For foster care, it's everyone 13 and over in the home, and we can do them for younger kids if there's reason to believe that it should be done. And that can prevent people from fostering, from getting a license, yes. In adoption, the background study technically is, the fingerprint background study required for adoption is technically on the adopting parents only. And so there's, again, some wiggle room in adoption, which is the permanent option, permanent placement versus a temporary foster home. So it doesn't always mesh together very well.
Right. So the rules for permanent adoption are easier than foster care.
Right. And again, adoption follows the Title 4E requirements, and they're the simple felony level conviction of a few things kicks you out permanently. And then there's a couple of 5-year kickouts, again, for felony level convictions.
Judge, with your idea, are you comfortable with the idea if let's say someone who's under 14 has an offense and they're in a family child care or a situation like that, does it change anything for you?
Yeah, because my suggestion is that anything under 14, we're talking about children that we really define as children, and we can't try them as adults even if we want to, because they really are kids. And I don't want to ruin children's lives because of something they did as a child without the capacity to understand the repercussions of. And I'm going to go back to that story of that 11-year-old kid who was in foster care and committed a sexual offense against another kid in foster care and became a lifelong registered sex offender at age 11. Now, I had him in court at age 31. He had never had another sexual or violent offense in that 20 years. However, he was an addict, surprise, and committed trespass and some petty thievery because he was basically homeless and he wanted to support his habit. But he almost got sent to prison for failing to maintain contact as a homeless guy with no phone with probation. And I think about him because I think he was 11. He was a child himself, very likely perpetrated on. You learn those behaviors somewhere, and he's been already removed from his parents' house, so that had its own little hell attached to it. And we closed the door to any life at age 11 because no one is going to, when you're a convicted sex offender and you have to register as a sex offender, your life's over. And for him, it was over 11. And I think, we hadn't given him any services. Who knows what he could have been or who he could have been if only he'd gotten care and therapy and whatever else it was that he needed, but he didn't get a chance and he was 11. I just think under 14 now, and I mean, that's the most serious of all offenses that everybody says, but boy, you hear a story like that and you just say, wow, he was as much a victim as the other child.
I agree, and I appreciate that very much. Does anybody have anything for Judge Kulik's recommendation, or should we move to Ms. Dawson? All right, let's move to Ms. Dawson. Ms. Dawson's idea was that you wouldn't use any juvenile records, but juveniles who were admitted into the EJJ program or were tried as adults, those records would remain eligible for the disqualification statute. Anybody have any thoughts? In a lighthearted way, we can always push back a bit. Any thoughts on that? Okay, good. We couldn't let her off the hook totally. Thank you, Ms. Sherlock, please.
Thank you. My pushback is just a little bit, I just want to ask to clarify, are you thinking it doesn't matter what crime it is, we would not consider it for juveniles, no matter what, no matter how egregious, no matter how violent. No.
And I think my thought was, yeah, just bringing it more in line with the federal, that's simple and easy to follow. And I understand, do I understand that there's pushback on that? Yes, but I also, I just, again, I go back to the juvenile brain development and even sex offenses, the likelihood of reoffending, and I think that often gets lost. Their likelihood of reoffending, for the most part, is actually really low. And I don't remember all the statistics, but it's, I think it's people get lost in the terminology of what the offense is rather than really who the juvenile is or the child is. So yeah, so that was the recommendation that I made, to be clear.
Yeah, for sex offenders, it's like 4% that they offend in that same category. Very, very low. And the thing that I just want to remind us all about is that we're not asking that they be employed. We're asking for them to be able to apply, go through the set aside process, and have an opportunity for DHS to say yes or no, right? And so it's not, we're saying yes, they can apply to ask to get a set aside. And so that's the other part of it. There's still the net to catch them to say no. And they're children that made a mistake, and there's still another filter to catch them. And so I think when we're talking about adolescents, that's an important thing for us to think about.
So, I mean, I would hope that let's all get on the same page on this, because I'm a little confused. And I apologize. My brain might still be at the bottom of the Grand Canyon.
It could be me too, John.
So, Ms. Evans, when you're talking about this, certainly the permanent disqualifications, a juvenile, just like an adult, is barred from requesting a set aside. But a juvenile who it's been determined has an offense that meets the definition of a misdemeanor, that's a 7-year disqualification, a gross misdemeanor for 10, and even the list of felonies that are 15, could always and can now request a set aside.
But she was just talking about egregious crimes. And so that's what I was.
Okay. But we're all in agreement, and maybe I just, like I said, a little space, but for the other ones, we're saying under Ms. Dawson's, you would not be disqualified. You would like therefore not
do over at 18, right?
Is that?
Well, I want to be clear. I think there's sort of two things happening here. So my original, just to throw something out on the table, was that juvenile record, so any adjudication, stay of adjudication, continuance for dismissal under the age of 18 is just not used, period. But then I did follow up with, I understand there's probably pushback on that. So that we would at least ask at a minimum that, especially for some sort of a permanent disqualifier, that a juvenile has the opportunity to apply for some sort of a set aside on a permanent one.
And that
so I want to be clear. I have the lofty, and then I have the minimum, if you will. So
I think we need to all be thinking that way. We need to have both of them, and we need to be willing to. And I think the goal of these discussions like today is to figure out what are the motivating factors that lead to these ideas, so we can maybe align what we think are our common goals of allowing people to move on, not creating a situation like Judge Kulik's 11-year-old, but protecting vulnerable individuals in our community. So where are those lines? And I think these suggestions, personally for me, help a lot, because I think I would imagine whatever we come up with, a recommendation is a bit of a Frankenstein of a bunch of these ideas, a little bit of this, a little bit of that, and so on. But having an idea why we're doing it makes a ton of sense to me.
And so, John, I would say even what I'm saying is even those tried as an adult and EJJ should have an opportunity at some point.
I get it. And it really strikes me too, and probably Gina and Dave and others who work in these fields know more than any of us, that a lot of times people that go through these really difficult times can bring an awful lot to the table to help other people not go through them. They seem to have, a lot of them, just an absolute gift for helping others, and we exclude way too many of them. And not only would they be safe, they'd be an asset. They'd be, they'd go the other way. So I think what our next goal is, Mr. Vogel, I think you and I are probably going to have to meet about this tomorrow, maybe for 15 minutes, include Vice Chair Evans if she's got the time, to just sort of figure out, we're going to come up with a list of these things, and we're just going to kind of circulate them. Just so they're in our inbox, and maybe start having a brief discussion with the full group about, here are just some of the darts we threw the first time we talked about it, trying to get some feedback from other people who have some thoughtful ideas. Before we kind of conclude, but are there other thoughts on any of the other ones? I mean, I think we can talk about always removal of the permanent disqualification with rehabilitation on all juveniles. I think that was raised. Mr. Page had come up with some small changes to the calculation. We'll include that. And then I don't know if we'll include this. I would defer to Ms. Dawson whether or not we should include sort of the 5-year property and another idea for, or should we kind of wait on that, Ms. Dawson, until that gets baked a little bit more?
I would say wait on that.
Okay.
And I'm happy to report back once the remedies kind of gets further, but I think we're still talking about that.
Perfect. If you have something else you want to add to the list, you have some epiphany walking the dog tonight, please send it forward to me and Vice Chair Evans and Mr. Vogel, and we'll do our best to add it. Anybody else have anything else? Yes, Judge, please.
Are we going to include no disqualifications for any offense committed under age 14?
Yes.
Okay.
Yes, and we'll distribute before Friday the list that we think it was, and if we've missed something or misstated it, which could certainly be the case, please reach out to us. But of course, Judge, we're adding yours as and really everyone that we discussed, we're going to have on that list. Anybody else? Well, great. I thank everybody for their time. I thought this was a really productive hour. I sad to say, I really enjoyed myself. But anything anybody needs, we're available. And I will see some of you guys in the morning.